think Anthony is going to fare in court? The house has been sold. So what's left for the court to adjudicate? This is an example of mootness. And today we're going to talk about 4 exceptions to the Mootness Doctrine in federal litigation and the Article 3 courts. So let's get started. So let's look at the issue of mootness. The issues in a case are deemed moot when there is no longer an actual controversy between the parties to that case. The case or controversy clause of the United States Constitution requires that the parties to a federal case must be involved in a justiciable controversy or one that involves an actual dispute or controversy. So the question is, between Anthony and Sam, there initially was a controversy, justifiable controversy, would you agree? But what happened when the property was sold? Is it still a justifiable controversy? What do you say? We're going to look at the 4 exceptions to the Mootness Doctrine. And these have been acknowledged and validated by the United States Supreme Court. And we're going to illustrate each looking at case law. The first one is voluntary cessation. 2, capable of repetition. 3, criminal cases. And 4, class action cases. Voluntary cessation. And this is what this looks like. When a defendant engages in an unlawful conduct, and that defendant stops his or her lawful activity after they are sued just to have the case declared moot. And then once the case has been declared moot, the defendant picks up where he or she left off, continuing or repeating their unlawful conduct just to achieve his or her unlawful end. And we're going to look at City of Mesquite versus Aladdin's Castle, Inc., 455 U.S. 283-289, and it's a 1982 case. And let me give you a backdrop of what happened in this case. The plaintiff challenged the constitutionality of a municipal ordinance that the plaintiff alleged was unconstitutional and violated his rights. While the case was pending, the city repealed the provisions of the ordinance, apparently hoping that the case would become moot. However, the court explained that a defendant's voluntary cessation of a challenged practice does not deprive a federal court of its power to determine the legality of the practice. And it concluded that the city's revision of the ordinance did not render the plaintiff's challenge moot. Why? Because the city's repeal of the objectionable language in the ordinance would not preclude it from reenacting precisely the same provision in the case if the case were dismissed on mootness grounds. The court concluded that it needed to confront the merits of the plaintiff's constitutional challenge. You can find that at pages 288 to 289. Capable of repetition, yet evading review. This is a situation where a dispute or injury arises in the short term and have the potential for reoccurrence, but it always fails to last long enough to permit federal judicial review. And the case we're going to look at is going to clearly demonstrate this. In such a situation, federal courts have justified an exception to the Mootness Doctrine. Defendant versus Old Guard, 416 U.S. 312, 1974. Here's the backdrop of this story. Defendant claimed that certain law school admission practices and criteria unconstitutionally discriminated against him on the basis of his race. While the case was pending, the commissioner began taking classes at the law school and was just about to receive his diploma. The court stated that Defendant's situation was not capable of repetition once he received his Juris Doctorate degree. It stated because the University of Washington Law School had agreed to allow Defendant to enroll and to earn a diploma, the case in question was moot. Defendant would be able to complete his legal studies irrespective of any Supreme Court decision. The controversy between parties had thus clearly ceased to be definite and concrete and no longer touched the legal relations of parties having adverse legal interests. And you can find this language at page 319. And regarding the second part of this doctrine, not evading review, the court opined with confidence that challenges by applicants would not evade future review. The third exception, criminal sentencing. The Supreme Court has articulated because criminal sentences are generally limited in duration, courts will sometimes be unable to rule on the merits of a criminal defendant's appeal before that defendant's sentence expires. Thus, the court has ruled that a criminal defendant who wishes to continue his appeals after the expiration of his sentence must suffer some continuing injury or collateral consequence sufficient to satisfy Article 3. In this case, Carafas versus LaValle, 391 U.S. 234, 1968 case illustrates this point. Let me give you the story. The petitioner appealed his criminal sentencing on the ground illegally obtained evidence had been introduced against him at his trial. From 1960 to 1967, while he was in custody, petitioner filed numerous appeals to get his case heard. On March 20th, 1967, petitioner filed a petition for a writ of certiorari, which was granted October 16, 1967. The respondent contends that the expiration of petitioner's sentence has mooted the case. Now, before we get into how the court held and how it came to the decision that it arrived at, let me tell you about some of the disabilities that the petitioner experienced as a result of the conviction of the criminal record. He could not engage in certain businesses. He could not serve as an official of a labor union for a specified period of time. He could not vote in any election held in New York State, and he could not serve as a juror. The court found these to be disabilities or burdens which the court concluded may flow from petitioner's conviction. Thus, he has a substantial stake in the judgment of conviction which survives the satisfaction of the sentence imposed on him. And he retained a substantial stake in challenging the validity of his conviction so that he could engage in activities that his criminal record would otherwise prohibit. And you can read this language at pages 236 through 237. So, the duration of the petitioner's sentence did not moot his case. Justiciable issues exist. Got it? And the fourth exception is class action lawsuits. In a class action lawsuit, the plaintiff represents not only his own interests, but also the interests of other injured persons. They are the class members. They are similarly situated to the class representative, the plaintiff, but are not named as formal parties to the lawsuit. And in these cases, intervening events may sometimes render the controversy moot as to the named plaintiff representative, but not as to the class members. And we're going to look at Bell versus Wolfish, 441 U.S. 520, 1979 case. And here's the backdrop of this story. Several pretrial detainees initiated a class action lawsuit challenging the conditions of confinement at a custodial facility, not only on their own behalf, the representatives, but also on behalf of other detainees as well. However, the named plaintiffs were transferred or released from the facility while the case was pending, and therefore were no longer being subjected to the allegedly unlawful conditions of the confinement by the time the Supreme Court took up the case. If you got the gist of this doctrine, you probably already know how the court ruled and probably know what the court said. So let's see. Here's what the court said. Although the named plaintiffs no longer had any personal stake in the outcome of the litigation, the class members who remained confined in that facility still potentially had live claims against the defendant. A justiciable controversy may potentially exist between a named defendant and a member of the class represented by the named plaintiff, even though the claim of the named plaintiff has become moot. You can find that language at pages 523 to 526. How many of you figured it out right? All right. So now you know the exceptions to the Mootness Doctrine and how they apply. I'm Advocate Lucinda, your empowerment lawyer, and we will see you next time. Take care.